when 3 police officers and 1 civilian come police informer carefully planned and executed the murders of an IJM lawyer, his client, and a taxi driver. They probably thought the law they so much enforced would never catch up with them, until it did. 7 years later, on that February 2023, the four stood in the dock in Willie Kimani law courts as Justice Jesee Lessit read their sentences. In this video, I will be dissecting the verdict given by the judge, explaining in details the role each had in the murders and consequently the varying sentences. I would suggest that you first watch one of my videos where I explain in details how the four systematically planned and conducted the murders as per informers' confessions and how technology was used to link them all to the crime scene. Find the video link in the description. Frederick Oleleliman hereinafter the first accused, Stephen Cheburet Morogo hereinafter the second accused, Sylvia Wanjiko Wanjohi hereinafter the third accused, and Peter Ngugi Kamau hereinafter the fifth accused. There was a fourth accused, Leonard Mwangi, who was acquitted due to lack of sufficient evidence in connection to the murders and the crime scene. These four were convicted of 3 counts of murder contrary to Section 203 of the Penal Code. The provision of the Penal Code under this section outlines that any person who of malice aforethought causes death of another by an unlawful act or omission is guilty of murder, and the succeeding section as read with provides a sentence admissible for the aforementioned offense. But the death penalty has been an emotive matter for the longest time, eliciting strong responses from both proponents and detractors. But an argument issued by petitioners in the famous 2017 case of Francis Karioko Muruatetu and another versus the Republic came just in time to not only settle the dust, but also to challenge our legal understanding and consequently provide for a new mode of implementation for the section. The Constitution of Kenya in Article 26(3) stipulates that a person shall not be deprived the right to life, save for circumstances provided by law. A scrutiny of the wording shows that the Constitution is permissive in that it does not make the death penalty mandatory. It is also restrictive, that is, the intentional deprivation of life, the death penalty, is an exception to the general right to life. Closely related to the right to life and likewise directly relevant to the issue of sentencing is a right to freedom and security, which includes the right not to be subjected to any form of torture, as guaranteed in Article 29. Therefore, a death penalty, which is a form of torture, contradicts the law. Since the legal statute overrides the Constitution, the Supreme Court declared the mandatory nature of death penalty as provided by the statute unconstitutional and granted discretion to courts in the exercise of sentencing persons faced with murder charges. The evidence tabled before the court served as proof that the murders of the deceased were a joint effort by the 4 accused, and the plan had been hatched days before the execution of the plot. The conspiracy involved high-level planning and organization. It was a sophisticated plan that employed the use of technology. On the material morning, the victims' movements were monitored in and around the courtroom and Mavoko law courts. Eventually, the 3 were trailed, abducted, and ferried in the abductor's vehicle, that is a private car, to a container at Syokimau AP post. They were locked up at midday and detained until nightfall without water. At around 9 p.m., the 3 were driven to an open field in Soweto. One after another, they were murdered and their bodies stashed in gunny bags. The bodies were disposed in the Athi River, then the assailants returned to Syokimau to have some meat and beer as if nothing had happened. From the circumstances of the case, the following were noted by the judge as aggravating factors. The murder was intended to pervert the course of justice by tampering with a witness, and this is the reason we have a case to begin with. It was a retaliatory move aimed at silencing one of the deceased. We shall be looking at this basis when we get to the roles each of the accused played. The offense was committed by a group. In the Penal Code under Chapter 5, Parties to Offenses, Section 20 terms any party to a crime as a principal offender if they fit one or more of these descriptions. 1. Every person who does the act or makes the omission which constitutes the offense. 2. Every person who does or omits to do any act for the purpose of aiding another person to commit the offense. 3. Every person who aids or abets another person in committing the offense. And lastly, any person who counsels or procures any other person to commit the offense. It is the first 3 cases that booked the 4 as lot in the list of accused, with the first accused being implicated by Case 1, the second and fifth accused being jointly implicated by Case 2, and Case 3 jointly implicating the third and fifth accused. The deceased were kept inside the boot of a car and taken out one at a time to be murdered. The murder was executed close by so that the victims could hear the thumping and blows being inflicted and the screams and shouts of their colleagues as they were being killed. The fact that each knew they would be next to face the same fate, it must have caused them extreme fear, stress, and psychological torture as they awaited their turn. Crude weapons were used to batter the victims and create excruciating pain. The autopsy reports into the deaths of the trio show that they were brutally beaten and tortured before being killed. Willie Kimani suffered a fractured skull after being repeatedly hit on the head with a heavy object. The taxi driver had injuries on his head and appeared to have been strangled. The client suffered the most, with injuries to his head, neck, and chest. He also had a fractured skull and blood in his chest. The deceased were put in Ghanaian plastic bags and dumped into the Athi River with the intention to conceal the murder and make the recovery of their bodies difficult. The murder involved flagrant and excessive use of violence on the deceased. The accused inflicted serious injuries upon the deceased, showing little to no regard for their lives and well-being. The first accused clearly had a grudge against the deceased Mwenda for reporting him to IPOA, but he still captured and killed Willie Kimani and Joseph Muiruri, not caring about their lives and the fact that they had not done anything to him to deserve what he did to them. They were collateral damage, but Mwenda didn't deserve the treatment he received from the accused either. On February 3, 2023, these four were jointly convicted of the heinous murder of a lawyer, his client, and a taxi driver, and this is how they lined up for the plot execution. The first accused is the pivot for this case. Every act or omission that constitutes an offense was conducted by him or revolves around him. The evidence laid before the court was proof that the murder of the deceased was premeditated and was hatched by the first accused. Entire coordination in executing the plot, the court attendance, the kidnap at a railway crossing, the detention at Syokimau Post, the disposal of the vehicle in which they were traveling in, the disposal of their mobile phones, the drive to Soweto open field, the murder and the drive to Athi River where the bodies were thrown over the bridge into the Athi River was all hatched by the first accused. Reason being, he feared losing his job. But let's get back to where it all began, shall we? Here's a slice of the backstory, but be sure to click the video link in the description for the full story. 1 year before the incident, the first accused shot Mwenda using a personal gun while on official duty and failed to record the same in the armory register. The gun wounds were very severe since they involved the chest and the upper arm, but after taking him to the clinic for first aid, he locked him up in the police cells for 3 days and charged him in Mavoko law courts with several criminal charges, including being in possession of narcotics, gambling in a public space, and resisting arrest. This marked the beginning of a prolonged and sustained harassment against Mwenda. Until out of sheer fear for his life, he approached Independent Policing Oversight Authority and International Justice Mission for help, and here is the point where IJM lawyer Willie Kimani got involved. The reporting was a success because it saw the commencement of investigations against the first accused, with possible punishment including jail time and/or employment termination should he be found guilty. With the help of IPOA, the first step undertaken by the lawyer and his client was attempting to obtain a P3 form from the station, which Mwenda had unfruitfully tried to obtain for months. However, on the receipt of the form, they realized the police indicated that a stray bullet had hit him, and this, among others, was a potential starting point for a lawsuit. Several officers and members of the public were called in to record statements, and things were getting sour by the day for the first accused. It is at this point that the first accused decided to mount a sophisticated master plan, which saw him capture Mwenda together with all those who were helping him on the mid-morning of the material day, and further events unravel as stated in Chapter 2. The first accused acted out of self-aggravation when he planned these murders. It was a vendetta against Mwenda for reporting him to IPOA, the aim being to destroy the evidence by erasing the complainant out of the picture, a very drastic action to take, to assault to injury. During the pendency of the case, the first accused is reported to have bribed the fifth accused with 15,000 Kenya shillings in exchange of a favor to keep his name out of his confessions. Being a police officer that had been employed and remunerated using public funds, his role was protect lives and preserve property. But he acted in flagrant abuse of his office and contrary to the duties and responsibilities he was employed for. The offense involved detention, inhumane treatment, and a huge disregard for human life and well-being. For the second accused, he stood by the first accused and stuck with him in every step, from capturing the deceased to their murder. He did not have any personal vendetta against any of the deceased. However, he played a very critical role of flagging down the vehicle the deceased were riding in, abducting and holding them in the police station where he was the senior officer in charge of duty. According to confessions given by the fifth accused, he and the first accused killed the deceased. For the third accused, her role was to keep the deceased person at the police post where she was the sentry and report officer all the way until the deceased were taken to be murdered. She had them in the police cell without being booked. She was the youngest and most junior in the group, and it is possible she might have suffered coercion. But during trial, she did not make any statement suggesting she was compelled. In fact, She denied any knowledge and involvement in the matter. She abetted and enabled crime and eventually concealed and denied any knowledge and involvement in it. Had she been candid at any stage of the investigations or trials, her honesty would have been considered as a positive extenuating factor in mitigation. However, to her credit, she was candid to her probation officer and admitted negligence in her place of work on the material day that was facilitative in nature. She played a critical role in plot execution, a role that was not peripheral as suggested by her lawyer. For the fifth accused, he made a confession to the police which helped immensely in the investigations by affirming the direction of the case. His role in the murders was to spy on the deceased and furnish the first accused with any worthwhile information. On the material day, he disposed the deceased phones and their vehicle in Limuru, a location proposed by the first accused since the taxi operated in Zimmerman, and therefore driving along Thika Road would have been risky. He participated in evidence concealment. After considering the mitigation of each of the accused person as given orally and in writing, the various reports that were filed, probation reports, medical reports, the victim impact report, as well as the various certificates of the causes undertaken by the accused person during incarceration, and also the circumstances of the case, the meticulous planning, implementation, and brutal execution of the deceased, the judge found the most suitable sentence for each of the accused person as follows. The first accused was sentenced to death in each of the 3 counts. The second accused was sentenced to 30 years imprisonment in each of the 3 counts with the prison terms running concurrently. The third accused was sentenced to 24 years imprisonment in each of the 3 counts with the prison terms running concurrently. The fifth accused was sentenced to 20 years imprisonment in each of the 3 counts with the prison terms running concurrently. The judge advised that in respect of the second, third, and fifth accused, the prison authorities take into consideration the period each had spent in custody during the pendency of the case. In total, the case had 185 court appearances and was adjourned 100 times. Many feel the case dragged in court for too long, but it's a relief that impunity was finally punished and justice was served to the bereaved families.